अस्सलातु वस्सलाम अलैका या रसूलुल्लाह वसल्लम अलैका या हबीबल्लाह। प्यारे व्यूअर्स, मैं हूं मलिक फैज़ मदवाड, एडवोकेट हाई कोर्ट, और आप देख रहे हैं मेरा यूट्यूब चैनल। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी नई आने वाली वीडियो आप तक पहुँच सके। प्यारे व्यूअर्स, आज हम पढ़ेंगे सेक्शन 339A। सेक्शन 339A पढ़ेंगे प्रोसीजर इन ट्रायल ऑफ पर्सन अंडर सेक्शन 339A। Number 1. The court trying under section 339A, person who has accepted a tender of pardon shall, before the evidence of the witness for the prosecution is taken, ask the accused whether he pleads that he has complied with the conditions on which the tender of pardon was made. Number 2. If the accused does not plead, the court shall regard the plea and proceed with the trial, and shall, before judgment is passed in the case, find whether or not the accused has complied with the conditions of the pardon, and if it is found that he has so complied, the court shall, notwithstanding anything contained in this code, pass judgment of actal. Section 340 Section 340 Right of person against whom proceedings are instituted to be defended, and his competency to be witnesses. Number 1. Any person accused of an offense before a criminal court or against whom proceedings are instituted under this code in any such court may of right be defended by a pleader. Number 2. Any person accused of an offense before a criminal court or against whom proceedings are instituted under this code in any such court shall, if he does not plead guilty, give evidence on oath in disproof of the charges or allegations made against him or any person charged or tried together with him at the same trial, provided that he shall not be asked, and if asked shall not be required to answer any question tending to show that he has committed or being tried or is of bad character, unless Number 1. The proof that he has committed or been convicted of such offences admissible in evidence to show that he is guilty of the offence with which he is charged, so or for which he is being tried, or Number 2. He has personally or by his pleader asked questions of any witnesses for the prosecution with a view to establishing his own good character, or has given evidence of his good character, or Number 3. He has given evidence against any other person charged with or tried for the same offense. Section 341 Procedure where accused does not understand proceedings. If the accused, though not as insan, cannot be made to understand the proceedings, the court may proceed with the trial, and in the case of a court other than a high court, such trial results in a conviction, the proceedings shall be forwarded to the high court. High court results in a conviction, the proceedings shall be forwarded to the high court with report of the circumstances of the case, and the high court shall pass thereon such order as it thinks fit. Section 342 Power to examine the accused. Number 1. For the purpose of enabling the accused to explain any circumstances appearing in the evidence against him. The court may, at any stage of any inquiry or trial, without previously warning the accused, put such questions on him as the court considers necessary and shall, for the purpose aforesaid, question him, generally on the case after the witnesses for the prosecution have been examined and before he is called on for his evidence, for his defense. Number 2, the accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answers to them, but the court may draw such inference from such refusal or answer as it thinks just. Number 3, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offense which such answers may tend to show he has committed. Number 4, except as provided by subsection 2 of section 340, no oath shall be administered to the accused. Section 343, no influence to be used to induce disclosures except as provided in section 337 and 338. No influence by means of any promise or threat or otherwise shall be used to an accused person to induce him to disclose or withhold any matter within his knowledge. Section 344, power to postpone or adjurn proceedings. Number 1, if from the absence of witnesses or any other reasonable cases it becomes necessary or advisable to postpone the commencement of or adjourned or any inquiry or trial, the court may, if it thinks fit, by order in writing stating the reasons therefore, for time to time, postpone or adjourn the same or such terms so as it thinks fit, so such time as considers reasonable, and may by a warrant remand the accused if in custody. Remand provided that no magistrate shall remand accused person to custody under this section for a term exceeding 15 days at a time. Number 2, every order made under this section by a court order then a high court shall be in writing signed by the presiding judge or magistrate. Explanation: reasonable cause for remand if sufficient evidence has been obtained to raise a suspicion that the accused may has committed an offense and it appears likely that further evidence may be obtained by remand. This is a reasonable cause for remand. Section 345, compounding evidence, compounding offences. The offences punishable under the section of the Pakistan Penal Code specified in the first 2 columns of the table next following may be compounded by the persons mentioned in the 3rd column of that table. प्यारे व्यूअर्स, आज तक के लिए बस इतना ही। मिलते हैं अगली वीडियो के साथ। इजाज़त लेने से पहले मैं आप लोगों से रिक्वेस्ट करूँगा कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। अल्लाह आप कामयाब से। अल्लाह हाफिज़।